All right. Welcome, everyone, to the early risers morning. We're grateful to have you all here. I'm Clark Casey, and I'm a professor of law at BYU Law School. We're excited to be hosting today's conference as part of BYU's Law's Future of Antitrust series. In addition to this event, we'll be hosting several upcoming conferences and webinars, so be on the lookout for those events as well. I think I've been allocated about 10 minutes for introductory remarks. I'm certainly the least interesting person here, so I'm going to cut my time short and just get to the first panel that we have for today. As you can see from the program, we have an amazing lineup of speakers, and we're really grateful that you all have agreed to come and share your insights and your expertise with us today on these important topics. And you're gonna have to forgive me in advance. I'm gonna do my best. Like, one of the most nerve-wracking things about today's events for me is finding adequate ways to introduce each of our speakers to convey all their remarkable accomplishments. I will do my best, but certainly fall short. I'd also like to thank BYU Law and Amazon.com for providing funding related to our Future of Antitrust series, and to today's conference organizers. Many of you work with Michael Holmes, without whom this event would not be possible. When things run smoothly, it's largely due to him. Matt Jenajon, also of BYU Law, has been instrumental in putting this event together as well, so thanks to him. And finally, Paul Stansel, one of our distinguished panelists today, who before going back into private practice recently, was at BYU Law for 8 years and helped get this initiative off the ground before he recently departed and left all the heavy lifting to us. So he will be here later as one of our panelists. One final note: if you are here for CLE, please, there's a sign-up sheet in the back at the registration desk. For those online, we have this late in the game due to popular demand, so CLE credit will not be available for the folks streaming in. Okay, so with that, I'd like to introduce you to today's first panel speakers, who will be taking part in our fireside chat. So we have David Higbee here on my left, moderating the discussion. David is a partner in Shearman Sterling's antitrust practice. He's the firm's global antitrust practice group leader, head of the Washington, D.C. office, and America's regional managing partner. Focuses on antitrust government internal investigations, merger review, works regularly on matters before the Federal Trade Commission and the Antitrust Division of the U.S. DOJ. Previously served as the Department of Justice at the Department of Justice Deputy Assistant Attorney General and Chief of Staff of the Antitrust Division, among other roles. Our two panelists, Diana Moss is the president of the American Antitrust Institute, has been since 2015. She was the vice president of the same organization before. Her work spans both antitrust and regulation, with expertise in a number of industries, including today's topic, digital technologies. Dr. Moss has also served in the Office of Economic Policy and the Office of Markets, Tariffs, and Rates at the Federal Energy Regulatory Commission, where she coordinated the agency's economic analysis for electricity mergers and contributed to the development of the landmark open access rules. Dr. Moss is also adjunct faculty in the Department of Economics at the University of Colorado at Boulder, and regularly publishes in top antitrust journals and has testified before Congress and federal and state regulatory commissions on competition policy issues. Next, we have Bilal Sayed, is a senior competition counsel at TechFreedom. Okay. Before that, Bilal was the director of the Office of Policy Planning at the Federal Trade Commission, where he helped the commission develop and implement long-range competition and consumer protection policy initiatives and advise staff on cases raising new and complex policy and legal issues. He's also been an attorney in private practice, representing clients on antitrust matters before the FTC and the DOJ. And he's taught antitrust law as an adjunct professor at the Antonin Scalia Law School at George Mason University. And he was also previously an attorney advisor for FTC Chairman Tim Muris. With that, I will turn it over to our panelists, and we look forward to it.
Thank you. Well, it is working. I didn't know that. I did see a light. So we appreciate everybody being here today. And I think our job is to maybe set the table for some of the other discussions this afternoon and identify some of the issues. And Dr. Moss, Diana, and Bilal both have experience at in the policy realm along and enforcement realm a long period of time, and can provide some perspective. And so we're going to review a little bit of the, I guess, history of enforcement in this space and the technology space as it's evolved in recent years. To start, I was reading an article earlier this week in The Atlantic. It was entitled "The Rise of Luxury Surveillance," and it described ankle bracelets and how these are used to track prisoners, and kind of compared implicitly the use of the use of modern day technology and the ubiquity of modern day technology that consumers voluntarily opt into to ankle bracelet technology. But we opt into this to take advantage of technology in our lives. The article mentions Apple Watch, Fitbit, various electronic payment devices, other health, Amazon Halo, other health technology applications, and I thought the only thing more ubiquitous than these technological devices are perhaps the proliferation of antitrust conferences talking about these issues and the interface of technology and antitrust law. But why is it that this conversation is happening so frequently? Why is there really anything different about technology markets that justifies so much attention being placed by enforcement officials, academics, and practitioners kind of in between on the interface between antitrust issues and technology markets? What's different, if anything, about these markets that justify this increasing attention? Either one of you. Diana, maybe I'll ask you first.
Sure. This is on, right?
Yeah.
Yes. Okay. Well, thanks to BYU and Clark and everyone else, and David, thanks for moderating. It's always an honor to appear on panels with Bilal. And this is a well-vetted topic at this point. I've probably given, I don't know, 50 talks on digital technology and competition over the last couple of 3 years. I think the digital tech sector raises a lot of really important questions for antitrust. It also clearly implicates the need to bring in more disciplines to bootstrap lawyers and economists in how we look at the digital tech sector. So AAI has a long legacy of doing multidisciplinary analysis. So we have worked with engineers, we've worked with psychologists and sociologists, and certainly the business school disciplines, marketing and strategic management, play a really important role in rounding out broadening the lens through which we can look at digital technology. My feeling is that the antitrust laws absolutely can and do apply to competition problems that arise in the digital sector. And we'll talk in a little bit about some research we've done on the digital business ecosystems and how unique they are from an economic engineering perspective, and why they're, what is the genesis of anti-competitive incentives in those ecosystems. So I think generally speaking, the law applies, and we should be able to get to the problems that are raised in the ecosystems. Whether the courts are going to buy into those theories of harm, for example, leveraging theories, is another question entirely. And that bigger question of antitrust being decided in the courts is certainly something that we should pay very, very close attention to, given the kind of case law that we've gotten out of the courts in the last 20 or 30 years, which is not great from a progressive perspective. If I were to say, what do we need more of? What would we need to emphasize or reform in the antitrust laws? We certainly need new standards. We have the horizontal, the structural presumption, and when it's enforced. I think we need a vertical presumption to address consolidation or integration in the ecosystems that has a distinctly vertical profile to it. Not all of it does. We also need to look at ecosystem mergers, which we'll talk about later, which I think are a unique phenomenon, and certainly a new standard for acquisitions of nascent competitors. That is how the ecosystems grow. And again, we'll speak about that in more detail. They grow through acquisition of very small rivals in building out their ecosystems. As I mentioned, I think we need to think about more novel theories of harm around leveraging. And I also think we may need to change the way we think about relevant markets in the digital tech sector. Herv Hobenkamp had that great article on cluster markets, which is really worth reading. And that is very on point when it comes to the digital ecosystem. So those are just a few tweaks. We can call them tweaks, but I think they're reachable well within, other than new standards, they're reachable within the existing rubric for how we look at and apply the laws.
Thanks, Diana. Bilal, let me ask you the same question, or to comment on it in a little bit different way. I mean, we've seen the antitrust laws, and you think about the whole breadth, Section 1, Section 2, Clayton 7, Clayton 8. You've seen application of the law in labor markets, in the technology industry and elsewhere. So it has been applied as Diana recommends. Do you think that its application has been sufficient, or is wanting in some ways?
Well, let me, I will answer that question, but I thought I heard a different question up front, which is, in a sense, why are we spending so much time talking about this? By this, I mean this general sense of, is antitrust, sufficient, up to the task? I think we're spending a lot of time talking about this because, we're in an era of very disruptive competition. We have a number of firms who are, moving into new areas from their, original roots because they were successful in those original businesses and have built out sort of new business models, both to support that their original businesses, and then expand into new opportunities that I think have some efficiency benefits with their original businesses. So, retail is being disrupted, distribution is being disrupted, the information industries are being disrupted, and that is in some ways perhaps unsettling. And perhaps, competitors, incumbent firms, legacy firms are affected by that new competition. And whether they are, genuinely concerned about competition as a process or concerned about their own survival, people pay attention to disruption. There are costs as well as benefits. And so I think that's why we're spending a lot of time on this, right? There are a lot of people impacted by this. And that triggers interesting questions, some of which, Diana alluded to. Do I think the antitrust laws have sort of been applied appropriately or sufficiently? The short answer is yes. Some may consider them hard questions. Some may consider them hard questions because of a predetermined belief that the agencies or plaintiffs sort of win more cases than they're winning. Others, such as myself, think a little bit deeper analysis of the benefits of this disruption should be pursued and should be celebrated. The one change, and I think there's one change I would make to the antitrust laws. I've said it before. I think there is an inordinate amount of focus on, type 1 error, right? A concern about over enforcement of the law. Now that's not included in any statute or in any guideline, but it is a theme that has started to, underlay some of the common law development. And I think from a economist perspective, you're not trying to minimize the sum of one type of error. You're trying to minimize the sum of, both types of error, over enforcement and under enforcement. So that's where I think antitrust can be adjusted. I don't think that's a statutory issue. I think it's something that should be argued to and developed in the courts. The agencies can take this approach, when they bring cases, and that I think may address what I call some of the process concerns in antitrust cases. On substance, the laws are flexible enough. I'm skeptical of sort of leveraging theory, but that's not a new concept in antitrust. Cluster markets are not a new concept in antitrust. Structural presumptions, if they're rebuttable, sort of fine, I mean, that's been the law for 60 years. So, to answer your question, I think we're spending a lot of time talking about this because there's a lot of disruption in a lot of industries by new players. Can we get it right? Yeah, and I think the one tweak I would make is just let's minimize the sum of the enforcement errors, not focus on either over enforcement or under enforcement.
But thanks. Both of your comments made me think of a specific illustration that I want to ask you about. Bilal, you said it's in part because a number of strong established companies are moving into new areas. Diana, you mentioned the importance of enforcement of in the nascent competition context. That both of your comments made me think of the FTC's Facebook case challenging its, at that time, 8 to 10-year-old acquisition of Instagram, which I think at the time it was acquired had 11 or 13 employees and was maybe one of 20 potential targets that Facebook could have bought. It's one thing to talk about the case that the FTC brought. Diana, would you say the FTC should have brought that case in 2011 or 2012? And if so, how would it have made that case one of a number of potential targets? If you say that, setting aside whether they bring the case that's been brought, looking back, would you advocate a regime that would have caused the FTC to flag that as a concern, which it did not during the Obama administration, and bring that case?
Yeah. So I think the way I think about the FTC case, which would potentially unwind Instagram and the acquisition of WhatsApp, would be that those cases should have been looked at more carefully when those acquisitions were proposed. I've done a fair bit of empirical analysis of enforcement in the digital tech sector, and if you just take the top 5 players, let's see, over the last 25 years, they've made probably at this point close to 1,000 acquisitions. Maybe a third of those are reportable under HSR. And the agencies have challenged 1 of those cases. So the average challenge rate as a percentage of clearances across all sectors, across both agencies, is about 15%. And the challenge rate in digital tech is less than 1%. So these cases, presumably the agencies did, they went through the second request process, they investigated, they looked. But the bottom line is, with statistics, that difference in digital tech versus all sectors, a lot of deference has been given to the digital tech sector. It's almost like enforcers didn't get on the, they didn't get on the train fast enough. They stood on the platform. You know, I think a lot of the arguments about why the digital tech platforms were bringing new innovation and new products and high quality services to users were really compelling. And so there was very little, if no enforcement whatsoever. Now we're seeing the enforcement. And assuming that these cases are successful, then the question is going to become, well, how do you unwind those, right? Is that a consummated Section 7 challenge where you go back to the state of competition that existed before the acquisition and devise a remedy that will get us back to that point? Or is it a Section 2 case in the FTC's case? Obviously, that's the route they chose. That's a very different kind of approach to unwinding acquisitions like that if the FTC is successful, and any of the other Section 2 cases, right? We were just talking at our conference, AAI's conference, on Live Nation Ticketmaster yesterday. I mean, talk about a monopoly. And it's not in the digital tech sector, although now digital tech is squarely in the ticketing space in distribution. We had a big discussion about how would you, if successful, how would you unwind these acquisitions? And, you know, there are these fault line issues, which are really, really important. How do you draw the fault lines around how to unwind an acquisition, given how much technological change has occurred since Facebook acquired Instagram and WhatsApp, how the markets have changed, new entry, changes in user behavior. Those are very, very difficult enforcers. And I would say right here that nobody's paying attention to how acquisitions would be unwound to fully restore competition, which is really what the requirement of a remedy is. So, you know, I think these are going to be really tough, difficult questions.
Is that an expression though of like an industrial policy preference that we would like, looking back, we would like the market to not look like it looks today, as opposed to charging someone with a violation of the law for, you know, taking what was a small company that mixed with its platform, they could blow it out on this platform. It could have done it with any one of the other 19 potential targets in it. I'm generalizing, but some number of targets that they might have acquired. And that's, I think, maybe one of the problems with nascent competition enforcement kind of methodology, how to do this right or well is understanding that, you know, any number of potential acquisitions might be expanded or strengthened on a particular platform, acquiring platform. But is that a violation of the law? And honestly, I think about, is anybody, when we think about, and this maybe goes into our discussion of the consumer welfare standard, is there harm here, or is it just that we like, is there consumer harm? Is there under the consumer welfare standard? I think of my wife's spontaneous or excited utterance, as we think of in the law. One night I'm reading, it's 10:30 at night, she's on her laptop, I'm reading, and she just blurts out, "I love Amazon." And I said, "Why are you saying that?" She's like, "I'm sitting here on my couch at 10:30 and I'm ordering things, and it saved my old things I've ordered. I don't have to go hunt for them. I don't have to get in the car and drive and all that." And to me, that's an anecdotal you know, measure of the consumer welfare standard. She's objectively feels like she is much better off because of the ability to do online retail shopping so easily.
Yeah, and I have the opposite reaction, which is I don't want my privacy and my user data to be used in a way that enriches algorithms through AI and machine learning. So I'm a user with, you know, a different reaction.
Yeah.
Well, I want to react a little bit to what Diana said, because I don't think it's just factually accurate, and that's not a criticism. It is highly likely that the top 5 platform companies or the top 5 market cap companies have done about 1,000 acquisitions over the last 25 years. I'd say it is very unlikely that 1/3 of them were reportable. I'd be surprised if 10% were reportable. I mean, based on the work we did, using both public and non-public data. That touches on other issues, but I think what that should suggest to people is that most of those acquisitions were very small acquisitions. In the study we looked at, in the 500-600 that we looked at the agency in the previous administration, we found about 80% of those transactions were valued at less than 40 million, and 70% or so were valued at less than 20 million. These did not look to me like acquisitions of nascent competitors. These look to me like acquisitions of technology as an alternative, to building that technology, so it could be, incorporated into products and, in a sense, brought to market more quickly than if that technology had been built internally. And I'd also say this is nothing different than any other companies do, right? The development of pharmaceutical, telecom, transportation, right? All acquisitions are in some sense a build versus purchase decision, right? Sometimes that purchase decision brings products, brings technology, brings new services to market more quickly than if firms build or try to build that technology themselves. So, I think we ought to be careful about sort of assuming these acquisitions have been problematic, and also that they are unique. Some of the work we did during that study, the 6B study of non-reportable acquisitions by what used to be known as the GAFAM companies, was sort of, did not make its way into the report, but Liad Wagman and colleagues, I'd say, replicated that work using public data and expanded on that work, and that shows a few things using public data and a public sort of taxonomy of acquisitions, that these acquisitions were not generally in the same space, and they were not really unique as compared to other so-called top acquirers in private equity and telecommunications and other fields. So, I think we ought to look at efficiency justifications for these acquisitions, not just market power or type explanations. Each case can be evaluated, on the merits, but generally we see a lot of acquisition activity historically across lots of industries, and that suggests to me there's sort of an efficiency rationale, not just a market power rationale. With respect to the FTC's case against Facebook and Instagram and WhatsApp, 10 years after the fact, I'll be careful there because I worked on that matter. But I think, it is hard to challenge small acquisitions. That is a problem in antitrust law, right? Because the future effects of those transactions are likely quite speculative. But I think that problem is bigger in markets that are small rather than large, right? And again, we just ought not to assume that acquisitions of 5-person firms or 2-person firms or firms with no sales are driven by the idea to take out competitors before they develop. I mean, there are a lot, I'll stop there. It doesn't exactly answer your second question, but I think it's relevant to that.
Yeah, it's interesting because my question is, how do you distinguish the cases early on? And Diana, do you think there's a distinction between an enforcement action of a Facebook, Instagram in 2011 versus a Visa Plaid, where you have motives? Bilal was talking about motives evidenced potentially anti-competitive motives evidenced in the DOJ's complaint in Visa Plaid. It cited, the executives drawing on the napkin was pasted almost a full page of the complaint with the volcano with some of the competitive elements that Plaid presented to Visa above the water and most of the volcano below the water, with all the ways that Plaid was going to compete with and potentially dislodge Visa. That was clear evidence in the documents of kind of competitive implications of the acquisition as opposed to buying technology. Is that the kind of thing the agencies could look at to really, to as a practical approach to make an enforcement decision? And in the absence of that kind of evidence, would a case be justified simply because it's a large company buying a smaller one? What are the objective tools that could be used to make a fair case?
So very good question. And I think some points of clarification. We're now at the point where points of clarification are in order. First of all, the use of antitrust enforcement as industrial policy is a terrible idea. And AAI has actually been at the forefront of talking about why antitrust should not be transformed into a tool of industrial policy, where the government picks winners and losers. And, antitrust supports competitive markets, right? And a market-based system and the democratic principles that underlie a market-based system. So any government intervention which picks winners and losers or attempts to use antitrust to shape or to steer a particular sector is really it's not a great idea. So we've been very at the forefront of that. Antitrust enforcement's also enforcement. It's about identifying anti-competitive conduct, mergers. It's about deterrence. It's about remedy. It's based on facts, right? And strong underpinning legal and economic and business principles. So there's that. And so if you take those two concepts, I think you're absolutely right that 10 years ago, even 15 years ago, the acquisition of a small rival by a Facebook or a Google or even a Visa or a Salesforce or an Intuit or an Adobe, naming company names that we don't hear very much, but these are up and coming players. They are acquiring their way to market caps, which are now going to exceed the market cap thresholds that are in Amy Klobuchar's Senate Bill 2992. They're coming up. And we did a whole study on the up and coming players who are largely being ignored. But acquisitions 10, 15 years ago of nascent rivals absolutely don't look anything like those today. And the reason why is because the digital business ecosystems have expanded dramatically. And I'm not saying those acquisitions are all of nascent rivals or they're all illegal. Well, of course not. They have to be looked at on a fact-specific case-by-case basis. But the ecosystems of today are not the ones that started out 20 and 25 years ago. What we see now is a deliberate business strategy to expand through acquisition. Again, there's no value judgment on that, but antitrust should be standing at the ready to determine if those acquisitions are potentially violations of the law or conduct in those ecosystems is a potential violation of the law. So what we see now are three types of acquisitions. One is to reinforce the platform, right? That's a horizontal acquisition. A second would be to expand cloud technology, which is the engine of growth in a digital business ecosystem. And a third type of transaction are what we call ecosystem acquisitions, which are applications that the expanding, now larger digital systems want to bring in. Google buying Fitbit was a perfect example of an ecosystem acquisition. Google buying Looker was a perfect example of an acquisition designed to build out cloud technology, right? There have been lots of acquisitions to build out a platform. So when you have bigger systems, when you have stronger incentives, you now have cloud technology, absolutely, the guts of the ecosystems, that's where a lot of this stuff gets played out in terms of strategic incentives and how to steer users through an ecosystem. You have a very different set of incentives, potentially more powerful incentives to reinforce and expand market power than you had 15 years ago. We just want enforcers to be aware of that. We want them to think like that. And frankly, some of the cases that have been brought recently don't think like that at the agencies. The United Healthcare Change Health Group case, They brought that case, the DOJ, I commend them for bringing the case, but they brought it like a traditional bricks and mortar vertical transaction. There is not anything in that case, that complaint, that would indicate that we're now dealing with a platform, a bigger platform in Optum, which relies on artificial intelligence and machine learning to enrich data and to potentially self-preference and discriminate against rivals on the platform. So I'll leave it at that.
So is the argument though that the case should have been brought more effectively, or that the antitrust laws are insufficient right now?
Oh, absolutely the first. Should have been brought more effectively.
Okay, so that could be though applied in lots of different contexts or cases, because some are arguing for a wholesale overhaul of the antitrust laws, saying they can't, they're not reaching current conduct, or they're not sufficient to encompass or address current markets. But there's an argument that cases need to be brought maybe differently or more sophisticated, that reflect the competitive dynamic of today's markets.
That is where AAI's thinking is we've got the laws, we have a very flexible consumer welfare standard. A lot more can be done to fully exploit the reach of the law and the reach of the standard. But enforcers need to think about the unique features of the digital business ecosystems and figure out ways to get at those particular issues.
Well, do you have any comment on that before I have a
Well,
follow-up for Diana?
Yeah, so look, I agree that the antitrust laws, just like other laws, ought to be enforced, and they ought to be enforced in a way that is, sensitive and takes account of changes in facts, changes in business, in our case. But let's just, how do the agencies bring these cases? They don't read the newspaper and think that's an industry or a firm I want to, challenge, right? They're looking at the business documents of these companies, and the people who best understand these markets are the people who play in these markets, right? And if the documents, the companies, if the evidence doesn't just sort of bear out these theories, the agency should not bring cases, right? There's, Diana mentioned that, the recent United Health case should have been perhaps brought differently. I don't have a view on that, but what I will say is, the agencies do a fairly sophisticated or in-depth analysis of transactions, right? Some they challenge, some they don't. In some, the facts are, the direction of the competitive effects are sort of unclear, but they are doing the analysis that Diana is talking about. And where they think there's a good case, I've not seen the agencies say the law is too difficult to bring a case. I mean, guys like Marcus Meyer on the healthcare side, Mike Moisiev, who's left, but in Mergers One, those guys will bring, and others, Jeffrey Green, those guys were bringing novel cases where they thought there was harm and the law needed to be moved. So, they're doing this, right? This is just, and they are aware of this, right? Of all the people in this room and in this discussion, the people who have the best sense, right, of these markets are the business people and the businesses, and the agencies are looking at what they're doing. It's a deep dive in the documents, a deep dive in the data, and not saying they get it right all the time. They over-enforce, they under-enforce, but they're doing this analysis, and they're not afraid to bring aggressive cases.
Diana, you mentioned industrial policy versus a law enforcement model, which we have. Where does regulatory kind of rulemaking fit in between those two? It seems to me that a rulemaking approach is setting up a system that more approaches the industrial policy, or could slip into that. But there are calls for more rulemaking or digital sector regulators in some markets, geographic markets in the world. what are your thoughts on rulemaking versus law enforcement and avoiding industrial policy approach?
Right. I think if you're going to go the rulemaking route, said more generally, the best repository for the rulemaking process would be a dedicated sector regulator, as opposed to the use of the FTC's rulemaking authority. As a former sector regulator myself in the energy sector, we lived and breathed open access rules and vertical integration and market-based rates, and the whole collection of types of conduct and the level of regulatory oversight that was necessary to ensure fair and open markets. Obviously there you're dealing with a very, a traditional vertically integrated model, but you're also dealing with the vertically integrated model and even a more complex ecosystem model with the digital business ecosystem. So I could as an economist, I could make a pretty strong case for you about why we might need to consider a dedicated sector regulator and to develop an open access regime for platforms, at least the platform component. That would stand in contrast to proposals, say, to break up companies, legislative proposals, which I think also raise a lot of questions themselves. So if we're going to go the rulemaking route, that would take the form of a dedicated digital sector regulator. I think Michael Bennett has a bill that would do that. It's not very well fleshed out at this point in time.
But how is that not a slippery slope into industrial policy and taking action against companies and regulating companies that have not been found to have violated the law? In the law enforcement approach, you have a neutral third party judge who makes that decision, who hears the evidence in an adversarial process and makes a decision.
Well, I mean, the answer to your question is it is industrial policy. If there is a decision legislatively to say develop a Digital Markets Act in the United States and to to mandate the development of a dedicated digital sector regulator, that's industrial policy. That would have to be based on a pretty bulletproof case that what we see in the digital business ecosystems is concerning enough to require that level of regulatory oversight. But with that, and I'm not saying that I'm proposing this or not, but it's definitely something that's been thought about, certainly in Europe. But just two more things on that. Support for a digital sector regulator comes from the fact that these digital business ecosystems are very unique phenomenon. They grow through acquisition, right? We see lots of market failures, right? We see information asymmetries around privacy. We've got one of our preeminent experts in privacy back here, Erica Douglas. We see data externalities, that's a market failure. We see enormous economies of scale and scope in cloud technology. All of this sort of creates a supercharged a business model where incentives to acquire and to enhance and to exercise market power can be pretty significant.
Well, you had a comment on regulatory approach versus law enforcement.
One of my favorite people, favorite thinkers, is Tom Krattenmaker. Tom with Steve Salop and Dave Sheffman sort of developed the raising rivals costs theory. But separate from that, I would talk to Tom about questions of antitrust law, and he knew we were thinking about platforms. And Tom said to me, he says, Bilal, there is a platform case out there. It's one of the greatest antitrust cases out there. AT&T was a platform case, right? The regulation of AT&T, the breakup of AT&T, that was a platform case. And I think that has not been studied sufficiently in thinking about, how we might think about enforcement versus regulation of platforms. And of course, the thing that sticks out to me is, right, AT&T was regulated, but it was protected, right? And, it's now sort of old, but how hard was it for the old microwave communications to get into the business of telecommunications, right? Microwave communications was MCI. They couldn't come, it was the regulations and the regulators that prevented that competition from developing in long distance service. So, I'm actually not as against industrial policy as a government policy, right? I mean, obviously that's what we're doing in the semiconductor industry now, right? The Trump administration was doing that with its concerns about the FTC's case against Qualcomm. And that's what the Biden administration is doing by putting $50 billion into that industry. So it's here, right? It's here, it's done. Whether it's going to be successful or not, who knows? But there are serious costs of a regulatory approach to competition. And I think the best analogy to the current tech platforms is the regulation of AT&T and the telecommunications industry. And it was only as that regulatory burden was lifted that we saw dramatic innovation in that business, right? So I'm concerned that a regulatory approach to platforms is going to stifle that innovation. There is nothing unique to the platform industry about growth through acquisition. I mean, this is true of almost every large company over the last 100 years, right? It's a combination of building on their own and acquiring new technologies, and sometimes product extensions. And there's nothing unique about network effects. In particular, the telecom industry is a great example of that. So those lessons, I think, need to be incorporated into some of the thinking now about platforms and I don't know, moderating their behavior or something.
Bilal, I'm going to just push back on something respectfully. In the study we did on growth by acquisition, it was an empirical study. We absolutely proved that digital business ecosystems grow more through acquisition than traditional business models. We developed a cohort study using propensity scoring to develop a counterfactual group. It's just a slam dunk. Digital business ecosystems are different. They grow through acquisition far more than traditional business models. So I'll leave it at that.
And on that point, if that's true, the question is it problematic, right? How do you determine whether it's problematic? And I guess you mentioned the study Market Power in Digital Business Ecosystems, or alluded to it, that AI did. How do, and you identified concerns or problems that you see with the digital business ecosystems. How are efficiencies and synergies taken account of? Because there's a lot of literature about efficiencies and synergies in digital business ecosystems as well. How do you account for those and those benefits and balance out the tension between those benefits and the concerns that you see?
Yeah, so back to the early discussion, what makes the digital business ecosystems unique? In the course of the conversation, I can add a couple more factoids. One is zero price markets, right? Consumers are paying with clicks and attention, and as they are engaged in the ecosystem. But antitrust can handle zero price markets, right? That attention can be a currency. We also need to think about how consumers behave in the ecosystems. Are they behaving rationally? Probably not. They make privacy choices that seem to work against their own interests. And the strategic management literature is really good on this. So is the marketing literature. So yeah, we got these business organisms that are very different. Can antitrust reach to those issues? I think the answer is yes. And in the process of looking and assessing competitive effects of conduct or mergers, absolutely. Enforcers, should consider as part of a burden shifting process what the pro-competitive effects of consolidation or conduct are. So I think the framework's there. The point I'm trying to make is enforcer, and we have been trying to educate the community and enforcers now for several years on the digital business ecosystems, also advocating strongly that antitrust should play it should play a role, but we're going to need other policy tools to sort of bootstrap. Antitrust shouldn't be required to take care of every single problem, you know, under the sun or in the digital business, in the digital sector. So yeah, I think the burden shifting process is alive and well and should be absolutely applied in this context.
Thank you. So I don't, we're going to run out of time before we have a chance to discuss vertical issues, horizontal vertical issues in more detail, or I think merger guidelines and some potential revisions that we'd hope to get to. I just want to ask one final question as we approach the end of our time, which is really about the gap between enforcement agencies and their ambitious agenda and where courts seem to be coming out. Not all the votes are counted, but early returns are not favorable. And so I would say, you know, Jonathan Cantor in his inaugural speech after being confirmed as AAG in January, I think it was the New York Bar Association speech, said, we're going to be willing to take chances. We need to be willing to lose some cases in order to try to move the law in new directions, essentially. They have been doing that. I mean, both the FTC through procedural and substantive approaches, the DOJ, both agencies have been aggressive in their approaches. I'm regularly counseling clients on a daily basis. This is the traditional antitrust analysis, and this is the likely path for a proposed transaction under a traditional antitrust analysis. But the world that we're in right now, it's kind of unanchored or untethered to precedent in some way, because the agencies have openly disavowed precedent, said we want to move the law in different directions and get judges to move in different directions. So what are your thoughts on the gap? And the agencies have now lost, at least the DOJ has lost a number of cases. We were proud our team litigated the Booz Allen merger last week. But what are the FTC had some wins in the vertical context. Lockheed Martin, Aerojet Rocketdyne is one that comes to mind. But what are your thoughts on the gap or the potential perceived gap between what the agency's ambition is right now and where courts who are actually bound by precedent might come out?
Well, look, I think the agencies should be ambitious. You know, the fact that DOJ's lost 3 merger cases doesn't strike me as especially problematic. Shortly after I left the FTC, you know, for the first time in 2005, under Debbie Majoris's chairmanship, they lost 3 merger cases at the district court level.
It's not just losing; you're going to get rulings that could, you know, could set bounds that have precedent.
Yeah, I mean, I'm not sure that's happened yet with DOJ's cases, but what I'm driving at is, you know, wins and losses don't need to be a measure of whether the agencies are a bit ambitious enough or too aggressive. They should be aggressive. Nobody else is going to be aggressive, and the enforcers and the laws ought to be enforced. I think, you know, enforcement should be grounded. Enforcement choices should be grounded not necessarily in a rational basis. That's other people's choice, but should recognize the law generally moves in small ways, not large ways. And cases that attempt, you know, to make large changes in law are unlikely, I think, to be successful, whether it's at the district court level or the appellate court level. And I think that to me is sort of the greater concern, what I call some sense that the agencies may just try what I'd call sort of Hail Mary cases. And there, I think they may solidify the law against them. Whereas an alternative approach of incremental change, right, where there may be, you know, differences in the law by circuit, or, you know, somebody, you know, the most recent case got it wrong, but a little bit older case thinks about it a little bit better, you know, is sort of the right approach. It's an approach, I think, that, you know, the healthcare shop has taken in at the FTC under their leadership. That's, I think, to me, the bigger concern, this sort of Hail Mary, you know, it's been wrong, you know, the agencies or the courts have gotten it wrong for 40 years. Let's go back and try to reinvigorate, you know, Brown Shoe, Continental Can, Vaughn's Grocery, you know, or even earlier cases. That to me is the bigger problem. You know, that they lose cases, so what? We all lost cases. That they're aggressive, you know, good for them, right? Aggressive antitrust is better than regulation.
Diane, any
Yeah.
risks to overreaching in terms of the substance of the opinions that might come out, or is that a risk you would be worth taking?
Well, I don't know that there are many choices here. The Biden enforcers have said they're going to bring more cases, different cases, and that's what they're doing. And advancing case law comes from wins and losses, depending on you know what side of the debate you're on. As sort of the leading oldest center left progressive advocacy organization around, we worry about the 40 years of case law that has been largely driven by Chicago school thinking, which that's now changing, which is a good development. But piling on more losses against already challenging case law, you know, makes us queasy for sure. So I think the question is, are enforcers bringing the absolute best cases they can bring in trying to push out, you know, push things forward here on this more aggressive agenda, or are they bringing cases but not bringing them in the best way possible? I would rather see a scenario where they brought the best possible cases they could bring, accounting for all the things I've talked about in my comments today, and the unique features of the digital sector. And if they do that, and their cases reflect new learning and a multidisciplinary approach, at least in digital, and they lose those cases, okay, fine. Well, you know, that's a different problem. But if they're not bringing the best cases they can, and they're losing on that basis, then I feel like that is a challenge to, that will just sort of, that creates a multiplier effect on 40 years of case law that really is not pro-enforcement case law. So it's a difficult situation.
Thank you, Dr. Moss. Thank you, Bilal. We'll hand it back to you, Clark. Proud that we're only 6 minutes over on the first panel.